Hi, I'm Keith Whittington. I'm a professor of law at Yale Law School, and I'm here today to share some information about freedom of the press, an important right guaranteed by the U.S. Constitution and applied to the states through the 14th Amendment of the U.S. Constitution. And you likewise will find freedom of press separately protected by many state constitutions as well. So today I want to speak specifically about questions of libel. And libel, slander are basically the same thing. They both fall within the broad category of what's known as defamation. And libel and slander essentially refer to how that defamation, how those false claims that hurt somebody might be publicized and communicated. Libel primarily focused on the written word. If you print something that is false and malicious and damages somebody else, as opposed to slander when you say something that is false and malicious and hurts somebody else. But for sake of convenience, we'll just refer to this as libel. And of course, libel has the most immediate consequences for freedom of the press, in particular, since the press is, of course, writing things. Concerns about libel and what the implications are for freedom of speech have a long-standing set of debates surrounding them that extends through American constitutional law and indeed precedes American constitutional law. And there are real challenges to think about how freedom of speech and freedom of press should cover things like false speech in general. So Cato's Letters was a series of pamphlets that were written in England in the early 18th century that had quite a lot of influence on the American revolutionaries and American founders as they're thinking about what kinds of rights one ought to have in a free government, ought to have in democracy and Republican form of government more generally. And Cato's Letters are particularly important in thinking about freedom of speech and freedom of thought as the founders understood it. Cato's letters were concerned with expanding the scope of freedom of speech and freedom of the press as it existed in England at the time, argued that England ought to be much less censorious and protect a much more expansive scope for the ability of subjects in England to express themselves without government interference. And as Cato's Letters referred to it, freedom of speech was the right of every man as far as by it he does not hurt and control the right of another. And this is the only check which it ought to suffer, the only bounds which it ought to know. That is to say that we ought to, within the freedom of speech, and for Cato's Letters purposes, and for many constitutional purposes, freedom of speech and freedom of press are interchangeable. For freedom of speech, we thought the rights of man ought to be able to speak whatever he wants. But again, there's this important constraint, as long as it does not hurt and control the rights of another, which of course raises questions about when might you speak in ways that hurt another person, that hurt the rights of another person. And then as a consequence, what kinds of speech or what kinds of printing might be such that the government can reasonably interfere and punish you for things you might say. And libel is one of those classic instances that were recognized in England as being a case in which you might write something or you might say something that hurts the rights of somebody else. And as a consequence, the government properly can interfere with your ability to say those things or punish you for something that you've said. And they can do so without encroaching on what was understood to be your proper liberty of speech. William Blackstone was an important jurist in England who helped summarize the state of English law and also reformed the state of English law as it existed just before the American Revolution. Blackstone was extraordinarily influential on the American revolutionaries and American founders as they were drafting their own constitutions. They took the kinds of rights that Blackstone articulated as being central to what the English body of rights were, and as a consequence, part of what they wanted to carry over into the American context and include within the American constitutional system itself. And so their starting point in thinking about what kinds of rights Americans had under their own US constitutions was Blackstone's writings about what kinds of rights existed in England more generally. And as Blackstone emphasized, as it was understood in England at the time of the American independence, people had a general right to freedom of speech and freedom of press, but that didn't mean they could write whatever they wanted without any consequences. As Blackstone said, it was consistent with a freedom of press for the state to punish you for things you might write under some circumstances. But the crucial thing from Blackstone's perspective was the government could not prevent you from publishing things in the first place. They could not impose prior restraints and censor what you wanted to say. But once you said something, once you wrote something, the state could potentially punish you for the content of what you said if, in fact, you're violating the rights of others. So as Blackstone said, freedom of press includes the right to punish, as the law does at present, any dangerous or offensive writings which, when published, shall, on a fair and impartial trial, be adjudged of a pernicious tendency, which is necessary to the preservation of peace and good order, of government and religion, the only solid foundations of civil liberties. Part of the problem with a board of censors, from Blackstone's perspective, is one censor could prevent information from getting into the public sphere. Part of what was important about punishing people after the fact, Blackstone thought, was if the government wanted to punish you for something that you said was harmful, they had to go to a jury and to a judge and persuade them that what you actually said was in fact harmful. And you had an opportunity to make your case that in fact nothing was against the law in what you said, nothing actually was genuinely harmful. And so there's a benefit of due process, a benefit of a trial that you might have for punishments after the fact. But Blackstone recognized it was consistent with the freedom of the press, as well as freedom of speech, to punish people when they said things or wrote things that had, as he characterized it, a pernicious tendency. The government necessarily had to be able to control things when people wrote things or said things that were damaging to society more generally. And the question then becomes, what counts as things having a pernicious tendency? What things are damaging to society? What's the scope of that is consistent with freedom of speech? And again, libel, one of those traditional examples. So when the US Constitution was written in the Philadelphia Convention of 1787, it did not initially include a Bill of Rights. That is, it did not include a separate list of rights that individuals had against the government, unlike all the state constitutions, which did have a Declaration of Rights, a body of rights, a Bill of Rights included in those documents or adjacent to those documents, specifying what kinds of rights individuals have. And one of the objections to the US Constitution was the fact that it was missing this kind of Bill of Rights. When James Madison, who is one of the key authors of the US Constitution, wrote to Thomas Jefferson, who at that time was serving as an envoy in France and was not a participant in the Philadelphia debates over the Constitution itself, nor was he a participant in the ratification debates about whether or not to adopt the US Constitution. But Madison shared a copy of the US Constitution with Jefferson and asked for his thoughts. And Jefferson was disappointed with the content of the US Constitution. And among his disappointments was that it did not include a Bill of Rights, which he thought was essential. And so among the things that Jefferson wrote back to Madison in response was some proposals for potential amendments that might be adopted. Madison was hearing a lot about constitutional amendments at the time. During the ratification debates, many of those who opposed the US Constitution were also proposing amendments in those state conventions, considering whether or not to adopt the US Constitution. Part of James Madison's response to those complaints about the US Constitution was precisely to promise people that the US Constitution could be amended, and in fact would be amended to take into account some of these concerns that people had. But part of what Thomas Jefferson proposed to Madison was a specific version that looks like the beginnings of the First Amendment to the US Constitution. And you saw similar kinds of language being floated in state constitutional conventions as well. But Jefferson's is interesting in part because it includes a reference to libel. So Jefferson suggests to Madison that there ought to be an amendment to the Constitution that says, the people shall not be deprived or abridged of their right to speak or write or otherwise to publish anything but false facts affecting injuriously the life, property, and reputation of others, or affecting the peace of the Confederacy with foreign nations. So from Jefferson's perspective, what it meant to say that you had freedom of speech or freedom of the press was that you could publish whatever you wanted, as long as it did not include false facts injuriously affecting the life, liberty, or reputation of others. That is, if it doesn't include libel. Notably, of course, the First Amendment as written does not have that explicit exception built into it. It just says you have the freedom of speech and the freedom of the press. But Jefferson's understanding that freedom of speech and press did not include libel, did not include that kind of defamatory content, was implicitly understood by everyone else who was writing at the time when they said, you have freedom of speech or you have freedom of the press, they meant you have the freedom, but in exactly the same way that Jefferson said, except, of course, you don't have the freedom to engage in libel. The Federalist Party, which forms under George Washington in the early days of the Republic, tried to leverage this and build on the example of Great Britain and what English law allowed at the time to go after what was characterized as seditious libel. That is, it's a particular kind of libel that's focused on libel against the government itself, libel against government officials. And this was a kind of libel that was punished criminally under British law. And the Federalist Party in the United States wanted to make this part of American law as well. So Congress passed the Sedition Act of 1798 as tensions were building between the United States and France, and there was concern that the United States would eventually find itself at war with France or potentially even with Great Britain again. Likewise, we saw the development of political parties and divisions between the Federalist and the emerging Jeffersonian Party that was critical of the government. And the Federalist Congress thought many of those criticisms of the existing government in the United States were going too far. Many of the Jeffersonians were too extreme in the kinds of criticisms they were bringing to bear against the President of the United States and against members of Congress more generally. So they passed the Sedition Act 1798 in order to impose criminal penalties on any person who shall write, print, utter, or publish, or shall cause to procure to be written, printed, uttered, or published, or shall knowingly and willingly assist or aid in writing, printing, uttering, or publishing any false, scandalous, or malicious writing or writings against the government of the United States or various members of the government more generally. The concern here then is to cast a very wide net to include both written statements and spoken statements that cast the government in a false, scandalous, or malicious light, which is the kind of argument and kind of concept that borrowed from libel law as it existed in England, that existed relative to private individuals, but carry it forward and say, not only could you not libel and say false and malicious things about other private individuals, you likewise couldn't say false and malicious things about the US government itself, about important government officials like the President of the United States, for example. And the concern here is that if people could publish things that were deeply critical of the United States government and were false and malicious about the United States government or about the President of the United States, it could threaten the very foundations of the government. It could potentially topple a Republican government. And so people ought to be jailed for engaging in that behavior. This set off an extraordinary debate in the early republic about whether or not Congress had the authority to pass such a law, whether they could punish people for this kind of speech, with the Jeffersonians arguing this kind of speech was in fact protected by the First Amendment and could not be punished. That this kind of harsh criticism of the federal government, even criticism that might be regarded as false or malicious, was protected by the First Amendment such that the government could not criminally punish them. The Jeffersonians, in fact, won the election of 1800, the first set of federal elections that occurred after the Sedition Act of 1798. Thomas Jefferson became president of the United States as a consequence of the election of 1800 and swept into power his supporters into Congress as well. Part of that election was understood as a repudiation of the Sedition Act of 1798. Jefferson immediately pardoned everyone who had been convicted under the Sedition Act of 1798. Prosecutions that were still outstanding under the Sedition Act of 1798 were dropped. And so the lesson that history took away from the Sedition Act debates was the Sedition Act was understood to be inconsistent with the requirements of the US Constitution. But there were no court cases saying that. The US Supreme Court at the time never heard a case involving the Sedition Act. So it did not become part of the constitutional law as articulated by the US Supreme Court, but became part of our constitutional memory and part of our constitutional legacy as a consequence of these political debates between the Jeffersonians and the Federalists. That this kind of seditious libel aimed at the government itself, was protected by the US Constitution and not outside the scope of the freedom of the press. Nonetheless, in the midst of World War I, the US government, the federal government specifically, tried to resurrect a version of the Sedition Act and passed the Sedition Act of 1918. And here the Sedition Act was somewhat more specific. The government argues when the United States is actually at war. So unlike the Sedition Act 1798, where the concern was we might become at war, in 1918, the government was at war. And so the government argues when we're actually at war, it shall be a crime of seditious libel, to willfully make or communicate false reports or false statements with the intent to interfere with the operation or success of the military or naval forces of the United States. And likewise, it shall be a crime to willfully utter, print, write, or publish any disloyal, profane, scurrilous, or abusive language about the form of the government. Many people were thrown in jail. Many presses were punished as a consequence of the Sedition Act of 1918, precisely for their criticisms of the war effort during World War I. But there's a similar concern here that the government's pursuing, which is one of saying, in this case, not so much that we'll necessarily topple the US government as such, but it will interfere with the war effort, make it more difficult for the United States to win World War I if you make false reports or false statements with the specific purpose of interfering with the military. And so this is much more narrow than the earlier Sedition Acts of 1798. It's much more focused on false statements that might have consequences for national security directly, and national security in the context of an actual ongoing war. But nonetheless, there were real concerns that this too would violate the First Amendment of the Constitution. And part of the lesson of the Sedition Act of 1918 that likewise we took away into the future was this was an abuse of government power, was interpreting the First Amendment too narrowly in order to rule out too much potential criticisms of the US government. The court finally takes an opportunity in New York Times v. Sullivan in 1964 to look back on some of these lessons of these earlier seditious libel cases, these political debates that were taking place around Congress and in elections about what the scope of the First Amendment was. And the court said that it recognized that part of the lessons, in particular of the Sedition Act of 1798, was that the First Amendment should be understood not to include exceptions for false speech directed toward government officials. As the court said in its majority opinion written by Justice William Brennan, authoritative interpretations of the First Amendment guarantees have consistently refused to recognize an exception for any test of truth, whether administered by judges, juries, or administrative officials, and especially one that puts the burden of proving the truth on the speaker. The concern here, as Brennan characterized it, is that erroneous statements are inevitable in free debates. And as a consequence, the public needed some breathing space to be able to say things in the course of public debates more generally, which sometimes they will get wrong. Sometimes people in communicating, for example, in our modern day on social media, will say things that are false. And what you don't want is the government to be able to punish people for saying false things in the midst of those kinds of heated political debates. People needed breathing room in order to have those public debates and not always be worried that every little thing they say, including every criticism they might launch at the US government, would necessarily be true and that they could prove that it was true in a court of law. So from Brennan's perspective, what we had learned over the course of American history as a consequence of these seditious libel debates was the lesson that if the government could tell you that there is a test of truth that the government could administer and could punish you for saying things that were false about the government, then people would be chilled in their speech. They'd be nervous about saying things that are critical of the government. And we could not have the free and robust debates about public policy that we needed to have in a democracy under those circumstances. So there's a real concern that the problem of having too big of a libel exception to the First Amendment was not that libel is critically important on its own terms to protect, but that punishing libel could chill speech, could deter people from engaging in robust speech because they'll be so worried that they might say something wrong, they might say something that's false, that they will refrain from saying anything at all. And as a consequence, we will get less important and valuable speech because of the fear that people might engage in libel, perhaps accidentally or perhaps in hindsight. And as a consequence, we need some more robust protections, even for libelous speech, in order to make enough space for speech to take place more generally. That's particularly motivated by this concern of seditious libel. What if you say false things about the government or government officials? But there's also a potential concern about ordinary libel. That is to say, libel against other private individuals, which is where the law of libel originally comes from. And most libel cases in modern American law come from as well. What if I say something false and malicious, not about the President of the United States, but about another private individual? Libel law allows that private individual to say, I've been injured by something that you've said that's false and malicious about me, and I should be able to sue you and recover monetary damages as a consequence of that false thing that you said about me. The question from a constitutional perspective is that kind of speech, the speech about other private individuals, for example, those ordinary libel cases, is that kind of speech raise any kind of First Amendment concerns at all? And if so, what kinds of constitutional restrictions might there be on governments about what kinds of penalties they can impose for that kind of speech about other kinds of private individuals? So the classic understanding of this, as it developed in early American law, as for example in this case, which comes out of the Massachusetts Supreme Court in 1808, so a very early example under state constitutions about what libel law meant in the early American Republic. Here, the court says, in the definition of libel as an offense against law, it is not considered whether the publication be true or false, because a man may maliciously publish the truth against another with the intent to defame his character. And if the publication be true, the tendency of it to inflame the passions and to excite revenge is not diminished, but may sometimes be strengthened. So what Chief Justice Parsons is saying here is part of what the government's concerned with is if I say something so malicious about another private individual, I might wind up breaching the peace. That is to say, the other person might be so offended and disturbed by the thing that I have said. He might feel so injured by the thing that I've said that he's going to have his passions inflamed, and it may excite revenge. That is, that person may then take revenge upon me for something that I've said. And the government has an appropriate interest in preventing that kind of disturbance of the peace from breaking out. And one way of preventing that from taking place is to prevent me from saying that malicious thing in the first place. But you'll note that what Parsons emphasizes is, from that perspective, it doesn't matter whether the thing I've said is true or false. That I can excite those passions, I can cause somebody else to want to take revenge upon me for saying malicious things about them if those things are false about them. But that may be true even if I say things that are true about them. And so the key that Parsons would emphasize about those classic instances of libel is the maliciousness of what I'm saying and not necessarily the falsity of what I'm saying, because it's the maliciousness that does the damage, not necessarily whether it's true or false. And in some cases, if what I'm saying is true, that may even heighten the damage. And as a consequence, the government may have even more interest in trying to punish that speech if it's true than if it's false. The US Supreme Court and likewise many state courts eventually decide that that's not consistent with what freedom of speech and freedom of the press should mean in the American context. That if we're going to have these kinds of robust public debates, if people are going to have the freedom to be able to speak their minds, we can't punish people, especially for saying true things, not even about other individuals. That we can at best only punish people for false things and under only very narrow circumstances. So to go back to New York Times versus Sullivan, this critical case about libel law that the US Supreme Court decides in 1964, here a concurring opinion from Justice Goldberg, that is an opinion that's agreeing with the majority of court about what the court ought to be doing in this particular case. Goldberg emphasizes the theory of our Constitution is that every citizen may speak his mind and every newspaper express its views on matters of public concern and may not be barred from speaking or publishing because those in control of the government think that what is said or written is unwise, unfair, false, or malicious. That is to say, in particular, when I'm criticizing government officials, I should be able to say whatever I want and without the fear that those government officials are going to decide what I wrote was false, was misinformation, what I wrote was unwise, what I wrote was malicious, and as a consequence, I ought to be punished for that. If in a democratic society, we need that capacity to criticize government officials, even if those criticisms are quite extreme, and even if those criticisms turn out to be wrong. And so as a consequence, the First Amendment has a genuine interest in what kind of libel ought to be protected relative to government officials in particular. And so at the very least, ordinary libel needs to be confined when we're talking about what the court characterizes as government officials or what it goes on to characterize as public figures more broadly. And across a series of cases that begin with New York Times v. Sullivan in 1964 and extends over several years subsequently, dealing with different kinds of situations, different kinds of libels, different kinds of actors involved in those libels, the court winds up arguing that the First Amendment restricts what the law of libel can say, that there are some constitutional implications for this traditional law of libel. So even though libel might be outside the scope of the First Amendment, it has to be narrowed so that it's consistent with the freedom of speech and the freedom of the press. So again, libel, that is written statements, or slander, that are oral statements, are not protected by the First Amendment, but libel has to be understood narrowly in order to be consistent with the goals of the First Amendment. So it's possible for false statements, that is not that traditional view of libel that includes even true statements. The court winds up saying only false statements can count as libel consistent with the First Amendment under the US Constitution. So false statements that cause injury to an individual can count as libel consistent with the requirements of the First Amendment. But the court emphasizes you must prove that those statements are actually false and that the defendant is at fault in producing it. That is to say, that the person that you're charging and you want to hold liable for what they've said, in fact, said the thing and knew that what they were saying was false. If this involves a defamed public figure, that is a government official, or ultimately, as the court characterizes, a celebrity, somebody in the news more generally, somebody who's part of public civil discourse more broadly, if that person thinks they're being defamed and wants to bring a lawsuit against you for something that you said or wrote, the court emphasizes those statements have to be proven to have been made with actual malice. That is, it creates a very high standard before public figures, especially government officials, but even celebrities, social media influencers, football coaches, and the like, can win a libel trial. And that is, actual malice requires that the person saying it had knowledge that it was false or a reckless disregard of whether it was false. And the goal here is to say, it's one thing for you to say something false about another private individual in daily life. It's quite another thing for you to say something false about a celebrity or about a government official. And you don't want deep-pocketed celebrities or deep-pocketed public officials to be able to sue somebody into oblivion as a consequence of something that they might say that turns out to be false on social media, for example, or in a tabloid or the like. We need that robust public debate about things people care about in public life more generally. And sometimes in the course of that kind of robust public debate, we may be conveying gossip and rumors that turn out to be false. The only way that a celebrity or a government official can hold you liable for a consequence of saying then something that's false on that in that type is if you knew it was false when you said it. But if you're just passing along rumor that you think is true, but it turns out to be false, then they cannot collect. On the other hand, if you say something that turns out to be false, even if you weren't sure when you said it about another private individual, that the government thinks and the court thinks you can be consistent with the First Amendment punished for, precisely because that other private individual does not have the same means of pushing back. They don't have the megaphone of being able to go to the newspapers, call a press conference to deny the rumor, for example, and so they're more easily injured by that kind of gossip and that kind of rumor mongering. Moreover, there's not the same public interest in passing along that kind of robust public debate about other private individuals. You need the freedom of people to talk about matters of public concern without worrying about libel protection, about the possibility you might say something that turns out to be false. But if all you're doing is talking about your neighbor, there's no similar public interest in being able to say you should get total freedom to be able to say whatever you want about your neighbor, because it's very important we have a public debate about your neighbor. And so as a consequence, the court has drawn a firm distinction between so-called public figures, people who are in the public eye and where we can have public debates about them. And sometimes we're going to make mistakes when we have those public debates about them, and private individuals who are not part of the public discourse. And in which case, those people are more protected against rumors and false statements, consistent with freedom of press and freedom of speech more generally.